Are you ready to do court reporter stuff?
Yes.
Okay. All right. Let's get on the record then. This is 24cv014632. And it is Ms. Allen and Ms. Williams in their official capacity versus technically the state of Georgia, but it's the state election board. And we are here talking about a subpoena and the issues that have arisen out of the subpoena. If I could have the appearances first for Ms. Allen and Ms. Williams.
Good morning, Your Honor. Michael Tyler, along with Alan Garrett and Jennifer Cotton, the law firm of Kilpatrick, Townsend, and Stockton, representing the petitioners.
Good morning. And it's Tyler, Garrett, and
Cotton, you're up.
Cotton, as in the fabric.
Exactly.
Excellent. All right. And Mr. Tyler, will you three be sharing responsibilities or mostly you?
This argument will be handled primarily by Mr. Garrett.
Okay, great. You are all welcome to speak. It's just helpful to know who's who.
Thank you.
And on behalf of the state.
Hi, Elizabeth Young from the Attorney General's office.
Hello, Ms. Young. So let me tell you where I think we are, and then I have a few questions, and then I will yield to the movant, which would be, I'm going to call it the county for short. There is a motion to dismiss. Well, I guess the movant is the state because it's a motion to dismiss the petition for declaratory judgment and injunctive relief that the county has brought in connection with the subpoena that the state has served on the county. And the state has moved to dismiss the petition. So in theory, I'll hear from Ms. Young first and then from Mr. Garrett or whomever. And then Ms. Young can wrap up. But I've got some questions that I think will involve all the lawyers. To recap, there was a long period when the lawyer said, Judge, just stay out of the way because we may be able to come up with a resolution, not to a motion to dismiss, but a way to manage this subpoena and get the state election board the things that it requested. And I know, Mr. Tyler, you and Ms. Young and I had a few teleconferences where the request was each time, just give us a little more time, we could sort this out. That's ultimately not what happened because it's my understanding that the county has yet to provide anything in response to the subpoena other than the petition, which is to say, we don't need to respond to the subpoena. There isn't the authority to bring it because it seeks information related to a closed investigation. And if we did need to respond to it, it is oppressive because it asks for things that aren't relevant, and it asks for things that would be particularly expensive to provide. And so that locked the two parties into the legal combat we're having right now, and that resulted in the motion to dismiss from the state. Is that it's high level and kind of loose, but is that a fair enough summary, Mr. Tyler or Mr. Garrett, as to where we are procedurally?
Your Honor, to a certain extent, it's very much an accurate summary. I would just note that we certainly were willing to look into the possibility of winnowing down the scope of the requests. As Your Honor will recall, there were 18 different categories. We were willing to see if there were some that in fact were relevant and relatively easy for us to produce without the excessive expense. As Your Honor knows, we have calculated $376,000 cost for full compliance. So we were willing in good faith to investigate that and did have a dialogue with opposing counsel about that process.
Okay, so it was a twofold. It was maybe we can sort this out. One way would be state election board, you figure out how to pay for all this. And the other more reasonable upfront approach was you want 18 things. I'll tell you what, these 5 probably cost $1,000 to produce. It's the other, I'm making the numbers up, but it's the other 13 that are so labor intensive and time intensive. And so maybe the board, the state election board, would be comfortable starting with these 5 items.
That precisely suggested what we explored.
Okay. Okay, thank you. Ms. Young, anything you want to add procedurally?
Well, I'd kind of just like to address that because I think we have a different take on that on behalf of the board. And you're correct. I think, you know, what I've been trying to do is what you typically do in a case like this that involves, you know, allegations of burden and excessive cost is you kind of try to look at the scope, you know, the number of the requests, sort of like you said, well, 18 might be expensive, but 5 are easy to do. And we've been unable to get, you know, any, you know, actual firm indication as to why the documents that are in electronic form that should be, you know, readily available cannot be produced. The response that we've gotten from Fulton is, oh, sure, you can have those. We can give those to you only if you drop the other 18. And that's where things have kind of fallen apart. We also, you know, have some questions about why is it that, you know, you have nearly a $400,000 bill for an election superintendent to produce documents that by law they are responsible to producing to any member of the public on request. You know, that is not to say that, you know, there may not be burden here. But, and this may be you know, something we'll address after we deal with the legal issues.
I think we're getting a little, I don't disagree with the question. I understand the questions you're asking, and I didn't mean in any way to poke my nose under the negotiation tent. So I don't want to get into a back and forth of, well, that's not what we said. I think we are here because whatever the negotiations were, they didn't play out. And I'm not interested in today assigning responsibility for the failure of the negotiations. They didn't work. I appreciate that time was spent on them. And clearly a lot of time was because we engaged several times and the request was, let us keep talking. And that didn't work out. So I guess since, well, you sat down, so that's okay. My first question that will help frame the discussion about dismissal is for you, Ms. Young, and maybe you were going to get to it in your presentation, so this will just come first. Part of your argument, part of the state's argument has been this vehicle of filing a petition seeking declaratory judgment and even injunctive relief isn't appropriate because there's an adequate legal remedy in place, which is 24-13-23. If the main pushback from the county, and this is all I've ever heard, it's never been, you may not have this. It's sure you can have it, but understand what's involved in producing this. And it sounds like the county has now, through council, spent a fair amount of time coming up with what they say is a good faith estimate. I'm going to round it at 400,000. It's easier to say that it will cost just shy of 400,000 to generate what is requested in the subpoena. And I think that will qualify by any metric as something where we'd need to engage into some burden shifting. Otherwise, it's unduly oppressive. Not that it's irrelevant. I'm not addressing that prong because that's a question for Mr. Garrett in just a minute. But what should the county be doing now other than bringing this petition saying, there's this subpoena, and we're not saying we won't comply with it, Judge, but we need some intervention from the courts because we don't have the means to do it, or at least the cost of doing so needs to be borne in part or entirely by the entity issuing the subpoena. What should they have done other than file this petition?
Well, so I think, and I think this is where the court could probably be of guidance at this point. Because Fulton's mentality seems to think that it seems to be that the subpoena is all or nothing. The subpoena, if you look at it, you know, it has a number of line items. Each of those line items requests some documents that are required by either statute or regulation to be maintained by the superintendent. Some of those are requested in electronic form. Some of them probably are in paper form where a box has to be opened and you have to find it.
750 boxes.
You know, but I think that one area that the court could provide guidance on is it all or nothing, or does Fulton have an obligation to at least start by producing Because that's what I typically see in subpoena cases is litigants walk and you need part of what you ask for and then draw a line at a subset of the materials that are requested. We have never been able to pin down with Fulton which of these, 18 or whatever categories of documents are the problematic.
Okay, I hear you. And my guess is that Mr. Tyler might say, well, that's not quite right, because the whole point of our conversation was we could give you this stuff on the cheap. It's the other things that would cost more, but that's not this morning. That may be soon. My question was a little different. I didn't ask it well. The county, I think, is entitled to knock on a courthouse's door saying, we got this subpoena. And one response has been, we don't think we have to respond at all because the investigation is closed. It's not relevant. I'm not asking about that. Another response has been, maybe we do need to respond to it, but we need to engage in burden sharing. And maybe that conversation hadn't gone well with the state. And so they turn to the court to do exactly what you just said, which is, well, maybe the court needs to get involved to say, all right, county, you've got a week to hang dollars on each of the 18. These three, we put $0 because it's the cost of a thumb drive, and the county they'll foot that bill. But these is when you need to bring in the people to scan it and a supervisor to watch the scanning. And my guess is the county could do that pretty quickly. But it has reached a point where the county feels like it needs court involvement to resolve the disagreement. The state is challenging this petition as improvidently brought, because the kind of relief they're seeking, either a declaration that the subpoena is overbroad or oppressive or irrelevant, or some form of injunctive relief, which I read as simply triggering 24-13-23. That latter, that it seems like any recipient of a subpoena is entitled to go into a courtroom to try to enforce, to quash it, or to get this form of relief. And my question is, what are you arguing is the mechanism to do that? If it's not this petition, and maybe it's not the declaratory relief they're seeking, because the subpoena is the subpoena. It's what?
It's to bring a motion to quash against the agency.
Okay.
In Superior Court. Some agencies provide for that to be brought directly before the agency. This board has not enacted rules that provide for that, so the remedy would be Superior Court motion to quash under the edit.
Okay, and that's what I thought the answer was. We see that more with foreign litigation, not meaning of other countries, but a lawsuit in California where someone is trying to get information in Georgia and the recipient of the subpoena doesn't like the subpoena. And so it's technically a lawsuit. It's just a motion to quash that subpoena for whatever reason, but that becomes its own, even though it's only a motion, that becomes its own independent action. Okay, so you're not suggesting that the county couldn't do that. It's just, that's the way to do it, as opposed to getting involved with paragraph 5 of et cetera, in the Constitution and suing the state because you can't sue the agency. All right, thank you for answering that question. I have a question for Mr. Garrett. What is the court's authority to look behind the subpoena in the way that I feel your responses are, and really the petition is requesting, to determine, is it being issued on good faith? Is it retaliatory? Does it relate to an investigation that is already closed? Why is that the court's business at all? And I analogize it to what we see on the criminal side, where a criminal defendant who's pulled over by an officer might say, he profiled me. But the law is, if he had a broken taillight, it doesn't really matter why he pulled over, because that broken taillight is a violation, and that is, the court's not supposed to ask the officer beyond the broken taillight. Well, but it's because McBurney was driving and you can't stand him, and that's really why you pulled him over. What's the authority for a court to be trying to divine whether this was a retaliatory subpoena, as opposed to looking at it, does this agency have subpoena power? And they're not subpoenaing the personnel records, they're getting election records. And that's what the board does, is it's the state election board. And so on its face, it looks valid. And so really the only thing we ought to be engaging in is the 24-13-23 analysis, which is it oppressive, et cetera. And so then it's back to where it seems like we ought to be focused, which is how do we allocate the burden of compliance? It was a long question.
I think I understand it, but I wanted to ask, do you want to stay here or go up there because of the camera?
I'm not so worried about cameras. I'm worried about you being comfortable where you are. So
Well, I'm happy here.
your tie looks great.
Oh, thank you.
Yep.
Thank you, Ernest. So I'm going to do my best to answer your question. And I think there's two dimensions that authorize court involvement. First is whether it's a lawful subpoena, which is to say, is it within the appropriate sphere of their investigatory power? Or is it, we know for all agency action, there's a limitation of arbitrary and capricious action.
Right. So my example of were they reaching out to Ms. Williams saying, we want to see the personnel files of all the people who work there and in animal control? Okay, well, that's not germane to what the state election board does, but that's not this subpoena. The subpoena is for 2020. That's a while ago, but it's election records. So it seems like it is in the center lane of what the election board looks at.
And Your Honor, to be sure, if there was a active investigation targeting a specific matter, right, that had not been relitigated multiple times before, right? We'll put the litigation to the side.
Okay.
Let's just say we've got a proper investigation on a specific matter.
But isn't the issuance, this is what I'm getting at, because otherwise you're asking the court to poke around in the internal operations of the issuer of the subpoena. The fact that the election board, as recently as this October, was it this October?
Yes, sir.
Issued a subpoena, 3-2, says to an outside observer, that's something they're investigating. Now, one could wonder why you are worrying about an election that was 5 years ago, when really we ought to be thinking about an upcoming election that's surely going to tax the system throughout the state, governor, senator, et cetera. That's a policy question. State election board, ought you not to be forward looking rather than way back in the rearview mirror so that you get a crick in your neck? But that's not my call. And those people who are responsible for appointing the members of the state election board might be wondering what the heck they're doing, worrying about something that happened 5 years ago. But that's their purview, not mine, not yours, not your clients. And so the subpoena has been issued and it is clearly in their wheelhouse. Like I said, they're asking for election records.
Well, if I may here break out our two grounds for objecting to the subpoena. So relitigation and maybe even the new subpoena triggers a relitigation concern because of the multiple times that the 2020 election has been litigated. But let's go into the subpoenas that give rise to this action. The other ground is retaliation. And here it's pretty extraordinary set of facts because we have the transcript. It's the state election board's own transcript, right? And it's, as I was preparing for this hearing, it's only 18 pages. It's not, you don't have to review 200-page deposition to excise 15 pages of pertinent testimony. The totality of it is an 18-page discussion. And this gets to actually a point I wanted to amplify from the briefing, so thank you for asking this question, which is we emphasize state election board member King's comments, and then obviously state election board, Dr. Johnston had made the motion to issue the subpoenas. But if you look at that 18 pages, it is entirely, they didn't agree to our 2024 proposed election monitors. Therefore, we're going to subpoena everything. It was a but-for relationship.
Was the October subpoena more extensive than the earlier subpoena, or was it a carbon copy of a renewal of the earlier one?
If by October subpoena, you mean October 2025,
Correct.
that was highly targeted, well, that was more targeted. It was basically ballots, stubs, and absentee envelopes.
When you say more targeted, meaning it asked for less than the earlier subpoena?
Correct. The earlier subpoena is basically every, subject, we could haggle over micro, but basically everything, or you'd have to review everything from the 2020 election.
So the earlier subpoena is the 18 category subpoena.
That is correct.
And the October last month subpoena was narrower.
Correct.
And is it your understanding that it supersedes the earlier, or does it ask for things that are not included in the subpoena number one?
Well, I'd certainly be happy for that to supersede, because then it's a finite universe of documents that frankly are under seal with this court. And I'm sure you're probably much more familiar with all this than I am. But if that's a finite universe, that would be a different animal to deal with. Now, we're not waiving our re-litigation objection. I want to preserve that.
Yep.
But that would be a different animal than what we have under the 18 item category.
Do you know if your client has asked the state, hey, does this supersede the previous one, or is it in addition to, or has that, I'm not putting Ms. Young on the spot. I'm just curious if you know that if that dialogue has happened.
I'm not aware that that dialogue has happened, but I welcome enlightenment on that.
Okay, Ms. Young, do you know anything about that?
Yes, I can tell you that the board's position is that the October subpoena does not supersede the earlier subpoena. They seek different categories of documents. The October subpoena is looking at the ballots themselves, whereas the earlier subpoena is more about process. It's looking for things like recap sheets and tabulator tapes, that kind of thing.
Okay, no, I knew subpoena one was broader. I just wasn't sure if subpoena two was taking a slice out of that and saying, hey, we haven't gone away and you need to give us this. We're going to circle back with the old one. But it sounds like it may be things in addition to what was in subpoena one.
Yes, it's the latter.
Okay. All right. That plays better into your narrative.
Well, thank you, Your Honor. Something from, I do want to pick up one more point from the October 2025 subpoenas, which is it was framed as an ABC, right? Ballots and stubs, envelopes. But then C was interesting because it's for our inspection and copy, right? Which goes to the second overarching ground of our petition, which is the burden shifting, right? Because the idea that the state would bear, and by the state election board would bear the burden of going through these documents and identifying. Now that it's still not going to be costless for our client, and I want to be clear that A, we're not waiving our objection in toto, and B,
No one's waiving anything today, so we don't need to keep saying, no one is waiving anything by being nice or saying, well, that could be right. Nothing is, no waivers today.
all right.
All right, it's a waiver-free environment.
Please preside over future hearings. Yes, it's if it wouldn't be costless because people have to keep their ironies. I mean, Fulton County has its own obligations to protect the security and the privacy of voter information. I mean, nobody wants people that aren't under appropriate supervision to go through the totality of, okay, I think we're all in agreement there. So with the understanding, but I was frankly excited when I first saw the new subpoenas for further along the lines of course, and I'd love for this litigation to come to an end, right? And so the idea that, okay, are they accepting that they have the burden to do the sort of mechanical photo inspection and copying, that was a useful tool to maybe move this towards resolution. So I had the same feeling, but I don't know. It's we've heard that this is not superseding.
Okay. Won't you spark one other question, two others. And none of this is quiz. It's okay if this isn't what we prepared for. Why are you over here, Judge? the things that are, so question one, Ms. Young, as part of her answer to me about how do we work through this, if it's not through your petition, what would another vehicle have been? Well, a motion to quash. Part of her response was, and all this stuff to be publicly available. And I'm curious if you agree with that as to the original subpoena. I just remember when I was first working with Mr. Tyler and Ms. Young looking at it, and it asked for things I've never heard of, which doesn't mean they're not publicly available, but I do believe that consistent with protecting voter privacy, that there are some things in the possession of the superintendent that you can't, I mean, I guess if a court ordered it, you could hand it over, but is everything publicly available? If I, as John Q. Public, did an Open Records Act that mirrored exactly subpoena number 1, would there be an Open Records Act exception to some of that because of privacy concerns, or it's not going to be state secrets or something like that? But how public is that stuff?
Well, I can say fairly certain, and I'm relying on your categorical protection waiver. I can say fairly certainly that not everything there would be concerns about at least some of those documents. So
okay.
I have a high level of comfort that that's the case.
Okay.
But number 2, the Open Records Act is a useful paradigm when you talk about overarching issue 2, because we all know, the state election board itself knows that there's a cost shifting vehicle in connection with Open Records Act. So there would still, again, there would still be some, Fulton County has this independent security and privacy obligations to protect, and there would still be caution.
Okay. Related question to Open Records and maybe the October 25 subpoena. The legislature in the last session amended 21-493, adding a section J.1, subsection J.1 and J.2. J.2 allows people to use the Open Records Act to get ballot images, just ballot images. And even though they may be under seal, the superintendent, so your client would not need to go to a court to unseal those ballot images. They are publicly available a certain amount of time after an election is complete. And I'm curious if subpoena number 2 is basically, it's not an open records request, but if it's asking for ballot images.
I have a 90% level of confidence that the state election board has already received electronic copies of the ballots. And I know.
So they're looking for things beyond that.
That's my understanding. In fact, I
Okay.
think there have been 2 inspections of the ballots.
At least.
At least, right.
Right.
Well, if they had a copy, I guess they could have inspected it to their heart's content. But there's also a physical inspection of the 2020 ballots, or at least it was reviewed electronically in the presence of.
Okay. I'm asking because I have related litigation where there's a concerned citizen invoking this J.2 provision that says, actually, your client, you need to get me the ballots at a certain resolution. And it does have cost shifting in there. But if everyone is asking for the same thing, then we ought to be thinking about, if it costs X, am I going to have to pay that as concerned citizen 1, Ms. Young as concerned citizen 2 have to pay it? Or does it make sense if enough people are saying we want copies of the ballot images to just get the ballot images out there? But it sounds like that's something that the state board already has and is not part of either subpoena 1 or subpoena 2.
Well, I'm not sure I'd say I'm not sure I'd say it's not part of it.
Oh, they want it again?
But one of our responses, for example, to the October 2025 subpoena was, we already gave you electronic copies of
Okay.
the ballots themselves.
Okay. And it has there's more to that statutory amendment about the quality of the images so that they're visible, et cetera. But it sounds like we don't need to go down that rabbit hole, because in particular, subpoena 1 is asking for so much more. It's outside the scope of that recent amendment?
Uh,
Because it's asking for far more than just ballot images.
well, I would like to achieve greater familiarity with the new amendment. And I'm not sure about its, I want to say retroactive because that's a late question. Retrospective, how about it's more neutral? It's retrospective application, but so subject to that, certainly.
I don't read it as going back to apply to the first subpoena. It doesn't apply to subpoenas. It has to be an Open Records Act request, and it's just for ballot images. I just wasn't sure where a request for ballot images fit in either of the two subpoenas. And the second subpoena sounded like it was more in that direction, but maybe not.
Maybe it's the second subpoena, Your Honor, that it encompasses ballots, the
Yep.
question of ballots, stubs, absentee envelopes.
Okay. Well, we covered as I was rereading the briefs and whatnot, those were the things I wanted to just sort of pick through before I said, all right, lawyers, make your arguments.
All right, well, Your Honor,
So unless you had something you wanted to add, now it's time for Ms. Young to say, here's why you should dismiss the petition.
well, I have been here enough to know that I will have plenty of opportunity to speak after Ms. Young speaks. So.
You will.
I think I'll come up to the podium just so that I.
Go for
it. Have this person on the screen. All right. So you've already, I'll try to not repeat anything that we've already gotten into. But I do want to start with the subject of our motion, which is whether or not this can be brought as a paragraph. We always call them just 125 cases. Article 1, Section 2, Paragraph 5 of the Constitution does allow for declaratory judgment actions to be brought against the state. Usually those cases are when there's been an allegation of a violation of the Constitution or a statute that has been enacted by the General Assembly. This is important in this case because, if the court adopts Fulton's reading of 125, then every case involving any action of a state agency or state employee or official is going to become a 125 case because every, tort, every subpoena, every investigation could be alleged to be outside the scope of their authority. And if their reading of this is correct, then all the existing statutory remedies that the General Assembly has provided for those things are out the window. Everything's going to become a 125 case.
Is your argument that because there is the remedy of 24-13-23, 125 doesn't apply, or it's that 125 was never intended to be so broad as to encompass concerns about a subpoena? Because they're two different arguments. If it's because there's another legal remedy, to me, that's a simple, and I don't mean this in a critical way, a more elegant one. Because if it's the latter, then that requires line drawing that courts don't like having to do. What is too broad? Is a subpoena challenge too broad for 125? But maybe if there was some persistent, allegedly unconstitutional action by an agency, that's not too broad, and drawing that line would be complicated.
Right. I certainly think both arguments could apply, but I'm happy to focus on the more simple, elegant solution of the fact that there is an adequate statutory remedy, and the Eternal Vigilance opinion specifically contemplated that, which is one of our most recent, expositions of 125 is, and what that is meant to encompass. And it specifically said, this is not supposed to substitute for an existing statutory remedy. There's really no need to create a new cause of action where one already exists. There are very few cases, I've looked for any case involving challenges to administrative subpoenas in Georgia case law I can find. There are very few of them, but those that exist tend to support the reading that is what the court asked about is it proper for an agency to be served with a motion to quash under 24-13-23? And I think the answer to that is clearly yes. Under 24-13-23B, it says who are you supposed to address such a motion to? And it is the person issuing the subpoena. And in this case, it's not a person, it is the state election board. So we would encourage the court to not allow the amended petition, to the extent that it raises claims under 125 to proceed in that fashion. We have not, I don't believe that Fulton has really made a alternative request to substitute the state election board in as the proper respondent. So at this point, I think the proper remedy is a motion to dismiss, or is the grant of a motion to dismiss. The Warbler case that came out earlier this year from the Supreme Court sort of looked at the situation in reverse and found that substitution of the proper defendant is appropriate. But in that case, you did have an attempt, a pending effort from that party to substitute. So as things stand right now, it looks to us that dismissal would be the appropriate remedy.
I want to make sure I'm following. I've welcomed Warbler because I've been involved in some cases where I had to try to explain to a poor petitioner, well, you sued the wrong person, so it's all getting thrown out, as opposed to, well, can't I just change the name of who I'm suing? And Warbler says, yes, you can. But I thought and maybe I'm misreading it, the petition is county versus state and not county versus state election board.
Correct.
Right. And isn't that the right formulation? Because you're not supposed to bring that action against the individual if it were the sheriff, or the agency, the sheriff's office, but it would be the county or the state. I thought that they got it right this time.
No, I mean, that would be true if it were a 125 case. But think about, for example, under the.
I misunderstood you. Yes, if it were a 125 case, I think
Then
it
the state
would have to be
would.
the state. But you're saying it really isn't a 125 case. Given that fact, then they've named the wrong party.
Right, and 24-13-23B says you are supposed to file a motion to quash against the person that issued the subpoena.
Okay, I don't disagree at all. I thought you were saying another reason why this should be dismissed is because we're traveling under 125 inappropriately, is your position, that they've sued the wrong entity because they sued the state. But I think if it's a 125 vehicle, it's got the right badging on the side, county versus state.
Right.
Okay.
And our position is that it's not an appropriate vehicle to be in. They need to be
Yep.
riding in a different car.
Right, and that car ought to have county versus SEB on the side of it.
Correct.
Okay.
And then, turning next to the issue of the legality of the subpoena, I think the court is correct that this is right in the center lane of the SEB's authority. There might be agencies out there where their investigatory power is limited to situations where there is an open pending investigative case. This is not one of those agencies, and there is a case out there, Southeastern Adjusters versus Caldwell. It is from the 1970s, but it's the only authority that I have found on point, and it's very specific. You look at the enabling statute that allows the issuance of the subpoena, and you see whether or not that subpoena power is tied to having a requirement of an open pending investigation. In that case, there was not an open and pending investigation, but the insurance commissioner's powers were sufficiently broad to allow subpoenas outside of that process. And that's exactly the situation here. If you look at what the state election board is authorized to do, it is to subpoena anything regarding any matter that is properly before the board. And then if you look at what the board is authorized to look into, any frauds or irregularities in elections, any procedural or process errors can be investigated. You can investigate it for the purposes of determining whether or not you need additional administrative regulations to make sure that errors don't happen again, or to, I think, to the extent that we can tell from transcripts what, you know, was in the minds of the several people that came together to vote on things. It's always a challenge with the board when you have people voting and they may vote for different reasons, but what has been articulated is very clearly that, you know, independently of you know, the 2023-025 case, you know, whether or not Fulton ever were to be taken to the Office of State Administrative Hearings for a penalty hearing is not the issue. That I think that the three voting members of this board would very likely all agree that they don't believe that the questions that were at the heart of that case have been answered to their satisfaction. And they do not need to have an open penalty case against Fulton County in order for them to continue to pursue that investigation and answer those questions.
And your basis for saying that is something in, I'm gonna call it their charter or their scope of authorities, or it's that case from the 1970s about the insurance commissioner, because that's the strongest parallel, that insurance commissioner could today decide, let's look back at what happened in 1980s when things got out of hand, and I'm worried they might get out of hand again. What could we learn from the mistakes that were made 40 years ago, because we don't want to repeat it now?
Right. Well, it's both. I mean, if you look at 21.531, that's the list of things that the board kind of has authority over. And, you know, you're right, it's not an unlimited power. For example, you know, the state
We
election
learned they
board,
don't have unlimited powers.
you know, I think.
Last litigative
I
cycle.
remember what
It's right there.
example that you were giving, but, you know, like they couldn't subpoena somebody's tax returns to start looking at, you know, and saying you violated tax law. You know, it's got to relate to those 21.531 powers, which include a variety of things, but, you know, looking into frauds and irregularities of elections, alleged violations of the election code, regulatory issues. There's a fairly broad ground, you know, delegation of power to them generally. And then if you look at 21.533, which is where the subpoena power comes from, the subpoena power is for any matter that comes properly before the board. So I think the proper analysis for this court to use would be, you know, probably, you know, again, there's no administrative case law on this point. You might get to make some. But, you know, I would say the 401 kind of relevance general standard, is there a general relevance to one of these enumerated powers in 21.531? And I think the answer to that can only be yes. Another thing that I think is very important is in 21.272, the General Assembly has said each and every single one of these documents is supposed to be available for inspection, not just by a board with subpoena power, but by any elector.
So you hinted at that when we were having our initial discussion, but you said it again, each and every of the documents, and I don't have in front of me everything of the 18-point initial subpoena. You are standing by research you've done, or the board assures you that everything in the first subpoena, my uncle from Valdosta could get if he asked the right way. It wouldn't be, you're not entitled to that, or that's not available. There's nothing they're asking for that guy in Valdosta couldn't
I would say
get.
there are one or possibly two exceptions to that. One are materials that are under seal with the court under 21.2.500. That's would have its own process that, you know, as you mentioned, there's this 21.2.493J.
And I'm less worried about the sealing. I mean, the sealing was appropriate at the time. These records are now historical records, and as long as personal identifying information is redacted, the sealing order is not an obstacle to disclosure. I don't view it that way at all.
That would be my thing number two, is if there would be anything with PII. But if you look at the subpoena, it's asking for things like consolidated return sheets. That doesn't have any voter info on it. Those are numbers.
Okay, but I want to go back to, you said there may be a few things that my uncle in Valdosta could not get. And you said maybe because things are under seal. Well, don't worry about that as an obstacle, but
there may be, and I don't believe the subpoena actually asks for anything that would contain a voter's PII.
Okay.
There is a numbered list of voters, but I do not believe, I cannot say it for 100% sure because I'm not sure I've ever laid eyes on one, that the numbered list of voters would have PII. If it did, it would have to be redacted.
Okay.
And we would, of course, make sure to take precautions against that. But if you look at everything else, these are really process documents. They are things like scanner tapes, recap sheets, recap forms, security seals. So digitized copies of the absentee ballot oath envelopes that could have an elector's date of birth on it, possibly that would have to be redacted. But the vast majority of this are not the types of documents that would have a PII concern associated
Okay,
with
but
it.
more germane to my question, there are also things that, if requested by a member of the public, absent a sealing order, could be provided.
Sure.
Assuming there was no PII on any of the things in subpoena one, it's all disclosable.
Yeah, if you look at 21-272, it specifically says that unless there is an outstanding court order prohibiting it, nomination petitions, affidavits, certificates, tally papers, returns, accounts, contracts, reports, and other documents, except the contents of voting machines, which the subpoena does not seek, shall be open for public inspection. And honestly, the process in 21-272, which doesn't on its face apply to the state election board because it is specific to any elector, and the state election board is not an elector. But I would encourage, in terms of thinking about it, assuming that the court finds that the subpoenas are within the board's power, what do we do about, the issue of production? The 21-272 statute provides, I think, a very appropriate model for how you would carry that out. And that is that, John Q. Public is entitled to come. They are entitled to inspect with supervision. Nobody's going to be allowed to run amok and mess with anything. So you'd have a county election supervisor, let the, board's investigators inspect. That would, I think, resolve a lot of questions about feasibility. If there is a photocopier on the premises, I am assuming there probably is at Fulton, but if not one, I'm sure the state election board could arrange for one to be brought in, because I know it's a warehouse. So maybe there's not. They could probably arrange for that to be brought in, and they could conduct inspection or scanning and copying under supervision at a much lower cost, I think, than Ms. Williams seemed to contemplate.
Okay.
In terms of motivations, I agree with the court. I don't think that there's, a judicially efficient way of getting into that. I suppose we could have an evidentiary hearing where we bring all the board members in to talk about the reasons for, all we really do have in the record right now is the transcript. I think the transcript really clearly shows that the members that spoke about this clearly have unanswered questions. And those questions are within their purview as board members. The fact that they are not required to have an open pending penalty phase investigation to answer those questions under Southeast Judge Justice versus Caldwell. So if, assuming that the court determines that, either that this is a proper 125 action to proceed against the state, which in that case, I think we would probably ask for a certificate of immediate review on that issue, just because of the importance and precedential value that might have in other cases applicable to a myriad of other agencies in other directions. But assuming that, for example, substitution were made and this became a 24-13-23 case, we think that there's really not a valid claim that the subpoena writ large is unenforceable. And we would ask that the court kind of try to set forth a process for getting the admittedly easy to produce documents produced to the board. We know that at least, even Ms. Williams in her affidavit said that the majority of the documents requires this big paper process. we'd like that at least the minority of the documents that are not subject to that process be turned over as a starting point. And then the court could, we would suggest, implement either something like a 21-272 type of process, where the investigators could come, inspect, take responsibility for copying on their own initiative. Or alternatively.
Can they do that? I thought that part of what the county has identified is the requirement that, and this may be I may be conflating this J2, this new thing where it's plain that the custodian, and by this I don't mean the clerk of court, so it would be the county election folks, they need to make the copies. Because only they can handle, you can't hand originals over to some inspector from the state. The originals have to be handled by the county. And so it would be the county, and it might be someone they've hired to do it, but not someone from the outside saying, hey, I'll take care of this for you, don't worry. Am I misremembering that?
Well, so 21-493J doesn't apply to anything in this.
It does not, right.
21-272 contemplates that you would use county copiers. It doesn't, I don't believe it says make and furnish to any member of the, so I do believe that implies that the election superintendent would make the copies.
Okay.
But I think if we start with the inspection, the board can identify which ones it needs to be copied, and then costs can be allocated appropriately at that time. Alternatively, I do think that there is, we do have a quote of nearly $400,000. I do think my client has questions about why Fulton's records are maintained in such a way that to produce very basic election documents that every election superintendent is required by law to be able to produce.
Well, we would work, if we get to the stage of, all right, let's map out the 18 different items and what type of cost are you hanging on them, county? This one's $2, this one's $300,000. We'd have to have a hearing about the $300,000 one, because I suspect if my ruling was, all right, state, how are you going to pay for that? It would be, well, can we confirm that that's really what it would cost? Because here's an expert who says it should cost half that. I mean, it's going to cost what it costs, and the dollars will be likely assessed to the requestor rather than the provider of the records. And I'm hopeful that your client's mindful of that, but it's not meant to be a process where you can just ring up a high tally because there's deep pockets on the other side.
Correct.
Okay.
But we do know, for example, the very first item on this subpoena is the consolidated return sheets, and by law, the election superintendent is supposed to have that, available and ready for inspection to any member of the public. Why would it be buried in 700 boxes of documents? So we would have I guess we would request an evidentiary hearing to kind of ask questions like that at the appropriate juncture.
Okay.
Thank you.
Thank you. Mr. Garrett?
All right, I will also take advantage of the podium, so I'm not a headless version of myself over on the camera. To address three issues, and I'm going to start with the practical one that you asked near the end about PII, because without exhaustively researching, certainly the absentee envelopes, that presents a big issue because you have addresses on those, names and addresses. And so that, when in and of itself, would be a substantial undertaking as a predicate to anything further that would happen with the absentee envelope. So I just want to note that we know that's a big one right now.
I've never voted absentee, so describe to the uninitiated, what's the issue with an absentee envelope?
Well, I'm not sure I ever voted absentee either.
But here you are saying, oh my gosh, those are radioactive. It would be so hard to
Well,
handle
I
those.
do know
And why is that?
that,
Because Ms. Cotton told you they're difficult, or?
it is my understanding that, well, it was a true statement that she did tell me, but, it is my understanding that there has to be like return address and so forth, and that, and as a predicate to the legitimacy of the absentee ballot, and I think that's been a dimension of the challenge.
Often, that if someone didn't get it quite right, then it's a defective absentee ballot, et cetera. But I just wasn't sure on the envelope, but maybe you have to fill in some information that can be validated. I don't know.
I'm not sure I can categorically state that, but
It doesn't change your argument.
It
You
has definitely
believe.
been my understanding throughout this entire process that the absentee envelopes must be redacted.
Okay.
I can say that.
Okay.
Okay. My second point, and I think I'll just briefly touch on this. I'm not sure I was able to say it correctly in the brief, but I'm going to try to say it again. It's like if on the paragraph 5, the vehicle question, if the state is saying unambiguously that a motion to quash could be filed against the state election board without the need for a separate waiver of sovereign immunity, right? Now that we're in this, the post-paragraph 5 world in SAS, or at least SASS, I assume I'm pronouncing it correctly, but it's like, don't screw it up. I mean, that's what we all learned in 2023, right? It's like, if I had that comfort, if I had the state in writing saying, absolutely, positively, you can do this, and there would be no sovereign immunity. Anyway, that's a different situation.
But tell me what your concern, and maybe it's buried in some of the litigation that's been going on here. What basis would the state election board have to dismiss a motion to quash if it was filed county versus state election board? It would be related to this. It would come here, 25 SC 1234, new action that you bring on behalf of your client, motion to quash 2 subpoenas, the old one and the October 25. And the style of the case is county election official, so Ms. Allen and Ms. Williams versus state election board. What makes you think that there is a sovereign immunity challenge to that motion? Now, granted, it becomes a civil action, but it's just a motion. And I don't know what the foothold is for the board to lean on Ms. Young to say, hey, you need to get that thrown out because we have sovereign immunity. You can't issue a subpoena and not be, I mean, you're invoking a statute that says if a subpoena is overly broad or, I want to get the right language, if it is unreasonable and oppressive, I think and means or, so either one or both, you are invoking, it's technically under the code section about evidence, but you're invoking that. What's the pushback from, I'm just trying to think from the criminal side, if someone is saying to the district attorney's office, you can't get this stuff, the district attorney's office can't say, you can't file that motion because we've got sovereign immunity. And maybe I'm missing, maybe it's as obvious as you are suing a state agency and where in the Constitution or in the Georgia Code, is there a waiver of the state elections board immunity for being sued, but you're not really suing them? You are seeking relief from an oppressive and or unreasonable subpoena.
I'm going to try to answer that in a 2-part answer, if I may. So
As many parts as you need.
part 1, I mean, yes, when the state said in this litigation, 24-13-23, I hope I'm getting that correct. Okay, good. 24, great, okay, we're making progress because as long as there's no ambiguity that applies. But if there's any ambiguity as to the applicability, right, then we have to be careful.
You don't want to waive anything.
Because Yeah, and this goes back to the early, the initial debate prompting the filing of the amended petition was that it was more of a pure motion to quash, right? And the state said, well, that's just injunctive relief, not tethered to declaratory relief.
Which you need to get to paragraph 5.
Right.
Right.
So, okay, fine, because really, there's a declaration that precedes any award of injunctive relief, right? There has to be a reason that you're granting injunctive relief, so fine. So we address that. But it's like if paragraph 5 operates inclusively, right? Then you want to navigate what you have to navigate for that. In other words, in the absence of some clear statement that agency subpoenas are subject to the normal rules applicable to all trial subpoenas, right? Then I wouldn't want to face an argument. But your point is well taken. Should we have a parallel action so that there's no way they can, I don't want to say there's no way they can escape, but in other words, that's an excellent point, and I've actually, a friend of mine, I think in prior litigation, might have done exactly that. So it's an excellent point. I'll take that, Your Honor. Then the last point that I want to touch on is the relitigation point and the general authority. And I understand the abstract point that if any member of the public could get this via an Open Records Act, how can we say the state election board? I mean, that's what I hear the court articulating. And I think, now I'm going to put aside the retaliation and talk about relitigation, which is agencies cannot litigate the same issue ad nauseum. If there has been a hearing that qualifies as a quasi-judicial action, if it's sufficiently like a court action and there's a final resolution, that should be precluded. Res judicata applies to agencies. We know that from the Georgia Supreme Court. And this is not an abstract question of whether there must be a pending investigation to issue a subpoena. I mean, we're not saying because there's no pending there can only be a subpoena if there is a pending investigation. We are not saying that. What we are saying is res judicata applies. And these issues, and let's just to oversimplify, double counting of ballots has been litigated has been litigated ad nauseum, right? Including in front of the SEB.
So why wouldn't I'm going to analogize it to qualified immunity, that an order from the court saying, yes, you need to produce this, but SEB, you cannot use anything that's being disclosed to bring a new, I'll have to learn the right terminology, but SEB can be investigating so it can make sure that elections in the future run more efficiently, effectively, fairly, less fraud, whatever their concern is. They also have the ability to look at what was done or wasn't in a jurisdiction and say, you messed up, penalty. And as I understand the briefing here, the state board looked at how things went in Fulton and concluded that no penalties should be assessed to Fulton County. That's your res judicata piece. And so I think there are policy reasons that have been articulated or could be articulated to say, all right, we can't reinvestigate that part, but gosh, this big election is coming in 2026, gubernatorial, senatorial, and we want to make sure that the things we were worried about in 2020 that in the end didn't rise to the level of a penalty being assessed against Fulton County, that they don't happen again. And to really understand what went well and what didn't, we need to look at all these documents. And so the order would be, yes, they must be disclosed, cost to be borne by the state. And PS state, if you were ever to bring a penalty action against the county in connection with the 2020 general election, you would need to demonstrate that you developed that investigation without relying on what's being disclosed now, because that investigation was closed with no penalty being assessed. And so you don't get to go back and do it again. Just like you can't try someone twice. You know what? We got a better piece of evidence. So let's put McBurney back on trial for that burglary. You had your shot and it didn't work out, state. He was acquitted. You can't try him again because you have this additional evidence. And so it would be, yes, must be disclosed to be used for any beneficial purpose that the state election board wants to use it for to make 2026 better and beyond, but not retroactively to say, you know what, we couldn't quite get you into that penalty box before Fulton, but now we did, and you're going to have to pay the price.
All right, well, I certainly at a minimum, res judicata should do that, prevent us being penalized for issues that have been fully investigated and closed.
But isn't that when you invoke the res judicata, you would say, wait, you can't reopen an investigation, start saying county, now we're pursuing this penalty, as opposed to board, you can't have these things that really anyone could get. But setting that aside, really, if any agency in Georgia, maybe other than the Secretary of State's office, is going to be asking for this, it's the state election board. It is so much in the area where you work and the things you do that how can we say it's not relevant to the kinds of things you're doing?
And that pivots me back to retaliation. And twice I heard my very professional, very competent adversary refer to properly before the board. She used that phrase twice, right? And I understand what you're saying. And if there was sort of this completely different fact pattern, right, where it's like, we have determined, that we need to get to the bottom of this, and these specific documents are highly relevant to our value. That's one thing, as opposed to what happened here, right, where they didn't give us what we wanted. We're mad. I mean, I think our first lawsuit had been filed. You may recall the first lawsuit, right? Which is, you can't do that. You can't force us to take your monitors. We're really mad about that. We're going to make them give us everything. It's not complicated, those 18 pages, right? And it's not one person. It's two vocal, and then there's the third that went along with them. But in any event, so I don't think there's any ambiguity that these subpoenas.
Well, now you say these, what is your basis for stretching the 18 pages of dialogue that maybe are emblematic of how that board does business and not the best representation of a state agency, stretching that all the way back to the original subpoena?
When I say subpoenas plural, Your Honor, I'm only talking about to Ms. Williams and Ms. Allen in 2024. There were two subpoenas in 2024.
Okay.
And those subpoenas were issued in October 2024 in retaliation for not agreeing to the 2024 election monitors. I'm not saying anything about the 2025 subpoena as being retaliatory.
Oh, I misunderstood. I thought you were saying, so the 25 subpoena, which is, I'm going to put air quotes around it, it seems like it's a smaller universe of material. That's not the byproduct of the 18 pages. It's the original two. They're two, but this because there are two people involved. But it's the original subpoenas that flowed. Your argument is flowed from the frustration that the county wouldn't take the state's monitors.
Yes.
Okay,
Factually,
but that's the timeline is, county says, that's interesting, but we've got our own monitors. We don't need yours. No, thank you. Oh, well, if that's the way you're going to play, here are these two subpoenas that ask for the 18 categories of material.
Exactly.
Okay.
Exactly.
So what is it you're saying prompted the October 25 subpoena?
They are, well, technically they're not part of this action, although the court definitely need to be made aware of them. I think the re-litigation issue remains.
Okay.
Right, to the extent.
But the argument about retaliation and asking a court to go outside the four corners of the subpoena relates to the original two subpoenas, not this October subpoenas. Okay, I had that.
Yes.
I had that backwards.
Yes.
Okay.
All right, if I may have 1 minute.
Mm-hmm.
All right, Your Honor. Well, if you don't have any further questions, I'm going to sit down.
I do have one more. What prevents me from recharacterizing your complaint as a motion to quash the subpoenas. We have a liberal pleading construct here in Georgia. It's not a pro se pleading. It's very, very well written with lawyers from a great firm. And it is getting at the subpoena being oppressive, unreasonable, maybe retaliatory, and it invokes constitutional provisions. But at heart, it is you should quash this subpoena, C 241323. But for reasons you've helped me understand, and part of it is based on how earlier litigation went with the state, the lawyers for the county chose the vehicle of the constitutional challenge or invoking that to get the declaratory judgment and then injunctive relief rather than the more direct route. And you've explained why, because you were concerned it would expose your client to a sovereign immunity. Court doesn't even have jurisdiction over a motion pursuant to 241323.
That is precisely the concern.
Right, but that's your concern. And so then the concern, I guess, the response to, well, Judge, if you recharacterize this as really it's an effort to invoke the protections of 241323, then the moment you do that, we expect there to be a different pleading from the state saying, sovereign immunity, you don't even have jurisdiction to consider it that way, Judge. If you're going to consider it, it's got to be the circuitous route of a declaratory judgment and then the injunctive relief that flows therefrom.
Let me just see if I can. All right. Two things, Your Honor. As you just articulated, and I think it's a fair conclusion, although I haven't necessarily looked at judicial estoppel in Georgia, but my goodness, if ever there was a fact pattern for judicial estoppel, it would seem that the state would be precluded from then coming back and saying, gotcha. You know what I mean? You're still doing it wrong. So with the understanding that the state would be bound to then, we would not be subject to dismissal on the other foot for sovereign immunity, I think we could live with that. Yes, Your Honor.
Okay. All right. Thank you.
Okay, thank you.
Ms. Young, as promised, you are the movant. So if there's anything you want to say in response to what we heard from Mr. Garrett, or in particular to my concept of recharacterizing the petitioner's petition is really a very elegant but overly sophisticated way of benefiting from the protections that I think they're entitled to try to invoke. Successfully or not, don't know. We'd have to have that conversation, but the protections inherent in 241323.
Well, I will say that, although there's very little litigation over administrative subpoenas, there has been some, and I'm unaware of any time where any state agency has ever taken that position that you cannot come into court with something along the lines of a motion to quash because it's barred by sovereign immunity. I can think of one that I handled for the Georgia, it's the State Ethics Commission now. It used to be called the Georgia Government Transparency and Campaign Finance Commission. A series of cases that we were actually the movant in terms of motion to compel on some of those, but there was one where we were on the receiving end of the motion to quash. We did not take that position in that case either. And we litigated that case on the merits. So that would be our intent here as well. I am aware that, especially following State versus Stass and Lovell versus Ravensburger 125 has scared a lot of litigants. And my hope is that with the Warbler case and that we'll not have so many litigants feel like they have to raise a 125 claim if what they really want to do is something else. So I think that may be the case here, and we certainly, have always felt that a 241323 action would be the proper vehicle for resolving the merits of this. I will kind of correct the record on, I was able to look up this, I could not remember either off the top of my head what is on an absentee ballot envelope. There is one side of the envelope that is just the oath of the elector and signature. There's no PIO on that. Side of the envelope, there is on the flip side a return address where you might put your return address. I am not sure whether my client would have any need to see that. So one solution to that might be, I need to talk to my client to just scan the one side
Okay.
or examine the one side.
And is that what actually goes in the mail? So what would be going through the mail is an envelope, the back side of which has this oath and someone has signed it.
But it does not contain, I thought it might have your date of birth on there, but it's actually the absentee ballot applications where really the PII is involved, and those are not requested by the subpoena. One alternate way, in terms of if, you had a subset of materials that would require extensive redaction, we would ask the court then think about perhaps confidentiality and protective order that would allow the board to receive unredacted copies and put that burden on the board to make sure that those copies do not get released in an inappropriate way. And the court, I'm sure, has done that in many civil litigation cases. I don't see any reason why the state election board couldn't benefit from that same treatment. And, in terms of this retaliation theory, again, I don't believe that it's worthy of credence. I think that the court has very correctly, identified that this is really exactly in the wheelhouse of things that the state election board is supposed to do. If, however, the court is inclined to give any consideration to that, I would say at a minimum, I don't believe that we have a record here that would justify quashing a subpoena on a summary judgment type of analysis where the court would find that, there's no genuine issue of material fact as to whether or not there would be retaliation. So at minimum, I think we would be looking at an evidentiary hearing, but I would submit that this, if you take a look at these subpoenas and what they're looking for, it is so clearly within the SCB's wheelhouse that I think we go straight to enforcement. And, if you look at the transcripts, yes, there is a lot of back and forth conversation, and they do talk about 2023-025. They do talk about how the agreement on monitoring fell apart. But you will also see in these transcripts members talking pretty passionately about their desire to get answers to these questions. And so from that standpoint, I don't think that there's any basis for a wholesale quashal of these subpoenas on that type of a theory. Thank you.
Thank you. Mr. Garrett or Mr. Tyler, how close is your legal team to being able to break out the cost estimate, which is pretty detailed, in the sense that it goes down to not quite a single dollar, but it's to the hundreds, allocating that cost estimate across the different categories of items that were requested in the first batch of subpoenas?
Your Honor, given the fact that we're in the midst of a holiday week, I really don't want to hazard a guess in terms of what might encumber the staff, but certainly I think that but for the holidays, within a couple of weeks, we should be able to have that.
Okay, I wasn't asking, I'm not giving any assignments this week. Don't need to worry about that. I just was curious if, and I'm not asking you to reveal work product, but if your team had already, not what could it do over Thanksgiving week, if it had already identified, well, there are 18 different categories. I think the number I used before was 5 and 13. These 5 are the time sink. These 5 are the ones where we need additional staff and a supervisor, et cetera. The other 13 are largely digital. There's not a concern about PII. And so those would be negligible costs that frankly the county would just absorb and hand over. And so I'm curious if that type of categorization has already happened.
I think in good order to state that, yes, to the extent that we came up with that figure, as precise as it was, it did reflect a very focused deliberation by the part of the DRE. So certainly some of that analysis has been done, but not to the granular level that the court is now suggesting.
Okay. Good to know. Mr. Garrett, Mr. Tyler, anything else on behalf of the county?
We're good, Your Honor.
Okay, all right. Ms. Young, you had to fly solo today. Usually have a sidekick. Anything more from your side?
Ms. Yu's out on a medical leave.
Oh, okay.
Regrets.
All right,
And she will be back, I'm sure.
good.
Future year.
Anything else from the state? All right, well, thank you, everyone. I will take this under advisement. If I need any additional information or need to be pointed in the direction of information that's in this big record somewhere, Ms. Niles will reach out. She'll always reach out to both sides, even though the question might be, hey, Team County, where would we find this? You'll know whatever the question is, Ms. Young, because you might say, don't worry, they don't need to find it here. I've got it for you, whatever that may be. All right. Everyone have a safe holiday. Hopefully you're not trying to get through the airport over the next few days, but people are coming to you. And I will be in touch soon.
Thank you, Ron.
Thanks. Oh, and you all will settle up with I don't know who requested the court reporter, but hopefully everyone will join in on that.
Oh, shit.
Yeah, send it to the state.